Ms. Corcoran.
Mr. Chief Justice, and may it please the Court, the executive order's stripping of citizenship from U.S.-born children is contrary not only to the 14th Amendment's plain text, but also our common law history, this Court's precedent, a federal statute, and over a century of executive branch practice. Every court to have considered the issue agrees that the order is blatantly unlawful, a determination the stay application does not challenge. The government instead argues that Article III and equitable tradition categorically prohibit providing non-party relief from the order's enforcement, regardless of the order's illegality or the irreparable harm it inflicts. The government is wrong. It is well settled that preliminary injunctions may benefit non-parties when necessary to provide complete relief to the plaintiffs or when warranted by extraordinary circumstances, both of which are true here. The Court should reject the government's efforts to stay a preliminary injunction that maintains a status quo all three branches of government have ratified and operated under for over a century, and that prevent the catastrophic consequences that will result for the plaintiffs and our country if the government is allowed to execute an unconstitutional citizenship stripping scheme simply because legal challenges take time. I welcome the Court's questions.
You say the government is wrong about the availability of preliminary injunctions. On what do you base that?
So I think that the two reasons I identified, one, it is well settled, and I understood General Sauer to agree today that universal injunctive relief is appropriate when necessary to provide complete relief to the plaintiffs. That is the case here, and I'm happy to talk about that. But I also, this Court has long recognized the availability of universal injunctive relief in extraordinary circumstances where it's justified. I think I would focus particularly on the public interest and equities prongs of the winter test, and I'm happy to talk about that as well. But I think those are the two reasons the government.
Do you think that if even if one considers the history not to support you, that the pragmatic considerations and the policy considerations should override that?
So again, I would put us in the complete relief bucket. So Mr. Feigenbaum, I'll put on my amici hat in answering that question. I understand General Sauer's proposal to be that we channel all of this through Rule 23. I think that is a historical one. It's inconsistent with the Rules Committee's understanding of the rules. Both, if you look at Rule 23, Rule 65, and Rule 71 together, they establish that Rule 23 is not the channeling mechanism that the government's suggesting. I'll start with Rule 71 because it's responsive, Justice DeBarrett, to your question earlier about whether non-parties can enforce orders. Rule 71 explicitly contemplates that and says if a non-party receives relief, they are entitled to enforce it. I'd point also to Rule 65, the preliminary injunction rule. In 2017, the Rules Committee considered a proposal from Professor Bray to amend the rule to prohibit relief to non-parties. The committee rejected that proposal because it found that it ran afoul of the Rules Enabling Committee. And then I'd end by pointing to Rule 23 itself, which says nothing about it being a channeling mechanism. In Principe v. Scarborough, this Court said, we don't treat the rules as excluding background equitable practices. And here, Rule 23 doesn't even contemplate preliminary relief. It's focused on permanent injunctive relief, and I think that's because, as we've been discussing, it's very difficult to get class certification in time to have preliminary relief, so you're doing putative class relief, which is the exact same thing as what's happening here.
Well, why can't you get putative class relief in a preliminary injunction or TRO posture?
You mean, sorry, in the
get relief for a putative class in a TRO or PI posture?
I certainly think you can. The Court did that recently in AARP. My point is when the Court does that, it's relying on the equitable authority it has to enter that sort of relief, not on the Rule 23 mechanism, because the class isn't binding until after certification, until after final judgment.
If that mechanism is available, whether one way or another, doesn't that solve a large part of the problem in a way that complies with the rules, the problems with universal injunctions that have been identified by administrations of both parties? Go through Rule 23 and do what's needed there, and people are bound then, so that's a wrinkle. But why doesn't that just solve the problem?
Right, so they're not going to be bound until after you get past class certification. So we're talking
I understand
about
that.
And for that reason, I would go to Justice Alito's point earlier that all you're doing is taking the non-party injunctions that are happening now outside of Rule 23 and shoving them into Rule 23. It doesn't address the forum selection concerns. It doesn't address the concerns about the emergency docket.
It complies with the rules. I mean, the law, we care about technicalities, and this may all be a technicality, but it seems to me the technicality of Rule 23 and the history of that provides, 23b2 provides a mechanism to do what's needed here in terms of getting relief to people. And if you have PIs available for putative classes, that seems to solve the issue for preliminary relief and the timing issue as well.
So B2 provides for permanent injunctive relief. It does not provide for preliminary injunctive relief. Again, Rule 23 does not purport to be the exclusive channeling mechanism. And as I said, the Rules Committee doesn't think it did. So it would be this court kind of projecting its own policy decision to treat Rule 23 that way. And I would come back again to Justice Alito's concerns. That is not actually addressing the court's emergency docket. It's just now we're slapping a label of class certification on it. So I would, and I'll make a second point on that and then say what I think the better way of approaching the problem is, which is I think that General Sauer and I are in agreement that the Venn diagram of cases that are appropriate for class certification and where injunctive relief I think would be appropriate is not coterminous. I think we could pursue successfully class certification here. I heard General Sauer to disagree, and I think it's because they're just different circumstances. If you look at the class certification requirements, commonality, typicality, they were actually added to Rule 23 in 1966, mostly to address the expansion of class certification to include damages suits. That makes sense there. But those were never requirements prior to 1966.
Ms. Corcoran, on the class certification point you've been developing, one response might be, and I just want to get your reaction to it, that by proceeding through the class mechanism, even a putative class mechanism, a court is making a preliminary assessment about who are the parties going to be before it and issuing interim relief so that it preserves its jurisdiction to issue final relief with respect to those parties. And that's very different, the argument would go, than simply saying everybody everywhere, nationwide, universally, or perhaps cosmically, stands to benefit from this decision without ever having to suffer being bound by it. Thoughts?
So I would say, again, that's an ahistorical approach. You haven't had that sort of Rule 23
assume for the moment that we read bills of peace, which I understand to be your best set of cases, to be prototypical of what is now Rule 23.
Right. And so the bills of peace and kind of going through, as Mr. Feigenbaum was talking about, Equity Rule 48 and then 38, in none of those circumstances were we doing this ex ante class certification determination. So the modern class action device actually looks quite different than it was for representative suits historically. So it would be putting on an ahistorical constraint.
I appreciate that argument. Okay, but then now we're haggling over the history, which we have to do. I accept. But if bills of peace are understood, again, accept the premise, to be predecessors of Rule 23, then respond to the point that there is something fundamentally different about a preliminary injunction to a putative class you found is likely to be certified and likely to succeed on the merits in order to preserve that court's jurisdiction to award ultimate relief to those parties before it, and that's categorically different than a universal injunction.
So starting with the presumption that was different about the bills of peace is that they were binding, I think sometimes, it's not clear always, at the end when they were getting to final judgment. I would go back to Grupo Mexicano, to Justice Barrett's point, although that was the high watermark of this equitable originalism, the way the court articulated the test, it focused on 1789, but the actual analysis in Grupo Mexicano focused on 1890 through 1942. And what the court found there is that there were numerous cases expressly rejecting the Moreva injunction, and that was confirmed in the 1970s when England adopted it and said, no, we've never done this before. We are in an entirely different world here. One, the cases that Justice Sotomayor laid out earlier all come from between 1890 and 1942, and they suggest that non-party relief was provided for outside of the class action context. But the fact that we have, I think, these very studied scholars in this rigorous debate about what the bills of peace meant, what the railroad cases meant, I think shows that this is very different in Grupo Mexicano. And for the court to kind of delve into that and adopt the categorical rule that the government is suggesting, I think is certainly an overcorrection. It's a hornet's nest on Article 3, right? It calls into concern APA, class action, a whole sort of things. I would suggest that the court instead focus on providing limiting principles within the confines of the Nikin factors of the winter.
Is there a practical problem? So I want to put aside the history, and I take your points on that, and why you don't think Rule 23 fits. I take your point on that. But if putative class actions and preliminary relief are an option, what then is the practical problem you see as distinct from the current regime?
Well, if General Sauer is right in that there are class certification problems here, then in this particular case, you're going to have thousands of
Okay, I think
suits.
you would be arguing that the class should be certified here.
Right, but I'm saying the government is
So
suggesting
more
that
generally, taking it out of this case, if you could, do you see practical problems?
Yeah, it would eliminate the associational standing trade cases, the cases brought by the Chamber of Commerce, the NRA, other associations that aren't suitable for class certification. I think also the questions, again,
Can you explain that?
Well, they wouldn't. So if we were to seek cert, it would be on behalf of our individual plaintiffs. For the same reason that the government would have difficulty seeking class certification. The state government, I think, associations are not necessarily a good fit for that framework. Again, that's also not solving the court's problem. It's just channeling the problems through a different mechanism.
I don't think that can be solved, just to be honest, but that's a separate issue from what the right rule is as to how things transpire in the district courts.
Could I perhaps try to solve it in a different way? What I would suggest, we spent some time trying to catalog the cases in which this court has approved universal injunctive relief and the cases in which it's rejected it with the aim of giving the court maybe a suggestion on how it might affirmatively articulate some limiting principles such that you would not be getting the injunctions that the court thinks are inappropriate, but the ones that the court has approved would still be able to proceed. Again, that's not the categorical rule that the government is suggesting. I think roughly what the court has been doing is saying that universal injunctions are appropriate only in facial challenges involving fundamental constitutional rights where there are real concerns about whether just the legal and practical availability of relief to similarly situated parties who are also going to experience irreparable harm. I think that maybe explains AARP. Most recently, IRAP would fall into that category. Crucifix, the New York eviction case, would fall in that category. On the other side of the ledger, the court seems to disapprove quite a bit of nationwide injunctions involving discretionary benefits. So that's some of the recent ones that you have undone or stayed. So I think what the court could do is kind of identifying limiting principles that would provide guidance to the lower courts on when it's appropriate to issue these injunctions. The natural home for that is the public interest prong of the winter test, right? If you're going to issue an injunction that's going to have an impact on other people's, you need to be doing a really muscular public interest assessment before doing that. So that's what I would urge the court.
Ms. Corcoran, are you pushing back on the class certification idea because you're worried that there are cases where there will be no certification, but in which broad relief is in fact appropriate, so
Yes.
that the two categories don't line up? And if that's why you're pushing back, why are you worried about that? What are the cases you're worried won't line up properly in that way?
The government has suggested it's going to argue that here. Again, I think the commonality, so thinking about questions like common injury make a lot of sense when you're talking about class-wide damages, less so when you're talking about a facial challenge to a constitutional violation. So I think it's a bit of a mismatch. And again, it's not what Rule 23 was ever intended to do. And it doesn't solve any of the court's policy problems. So I think it's a lose-lose-lose proposal that the government is offering. I'm a little concerned that I have focused a lot on my amici hat and haven't actually explained to the court why the injunction is necessary for complete relief here. But I don't want to pivot too quickly, but I want to make sure I address our primary argument as well.
Tell us why it's necessary for complete relief.
Thank you. For two reasons. The first is that a plaintiff-specific injunction would not be administratively workable. I'll explain that in a second, but I want to note the second one is that even if it were workable, it would require the association members to identify and disclose to the government an association that puts them at great risk of adverse consequences, detention or deportation, even if they're here lawfully. And so it's not complete relief to require the plaintiffs to make dangerous disclosures in order to claim the constitutional right. And then maybe I'll pivot back to the workability unless there are questions about that. Yeah. Oh, sorry.
Very briefly, and then we'll move on to the next stage of our questioning.
So the government's workability argument with respect to the individual plaintiffs, the private plaintiffs, is wholly tethered to its argument that the injunction should be limited to the 16 named plaintiffs. It has offered no argument for how it would administer, how state and local agencies could administer an injunction that was narrowed to the ASAP and CASA members. So I think that's probably the end of the road. Mr. Feigenbaum made the point that they can always go back to the district court and ask for the injunction to be dissolved if they present some sort of workable proposal. They haven't, and I don't think they can. I don't want to talk for too long, but if anyone is interested, I'm happy to answer questions about why I think it's
Oh, I'm sure someone will be.
Yeah.
Thank you, though, Counsel. Justice Thomas? Justice Alito?
Should we decide or make up our minds on the underlying birthright citizenship question without briefing and argument and deliberation?
I think that we would be very eager to do supplemental briefing on that. General Sauer noted that none of the parties had asked for cert before judgment. We couldn't because we keep winning. I will ask right now for cert before.
What's the answer to my question?
Yes, I think you can grant cert for judgment.
No, that wasn't my question.
Yeah, but I will say,
all right, that's all right. You don't want to answer it. That's
no, I will. I have if I could give an answer, which is that I think it's very difficult, if or not impossible, for the court to do a meaningful in-Ken analysis without taking into account the fact that the government is asking the court to allow it to ignore this court's precedent, to ignore a duly enacted statute, and to upend 100 years of executive branch practice. So I think, although the government has attempted to separate them, that really the merits are embedded in the in-Ken factors.
Justice Sotomayor?
I find it hard to understand how a district court, in looking at a preliminary injunction under the winter factors, where we said that the likelihood of success on the merits is the keystone, how we could separate that out and say the keystone of whether you're entitled to universal injunction is the only merits question because the other factors are not eliminated by winter. You have to balance the equities, and you can't balance the equities without the merits, correct?
I think that's right. I think also, irreparable harm is going to be very difficult for the government to prove if it's not contesting or at least not defending the constitutionality of the order because the government has no interest in enforcing an unconstitutional order. I'd also note there's a quote from Professor Bray in Justice Gorsuch's Texas Concurrence, and it's, "In equity, it all connects. The broader and deeper the relief the plaintiff seeks, the stronger the plaintiff's story has to be." So I think there really is kind of an equitable consideration here of the merits as well that just can't be extracted from the.
Now, the state has explained why it can't pursue class actions. So it admits it's limited to whether it's entitled to complete relief. But how about your organization? You sort of answered it, but I wanted to pin you down on that.
No,
Do you believe that associational organizations can seek class action?
I believe our individual plaintiffs certainly can.
Yes, there's no question.
Yeah, I am nervous about the government's suggestion that it's going to oppose our class certification motion if we were to file one. I mean, class certification can be very discovery intensive. It could be the sort of thing that really delays our plaintiffs from getting the relief that they seek.
Thank you.
Justice Kagan?
I guess what I worry about here, Ms. Corcoran, is that this case is very different from a lot of our nationwide injunction cases in which many of us have expressed frustration. at the way district courts are doing their business. And, you know, the typical way in which that frustration emerges is that legal questions are hard.